So the first thing I want to do today is to talk about building safety and to talk about the LPE1, or replies to landlords' inquiries, which has been modified just recently. There are additional questions generated from the Building Safety Act, and there are a number of things that I want to share with you. Firstly, certainly ARMA and other organisations are encouraging landlords to insert disclaimers or to exclude liability in connection with LPE1s, in particular with regard to building safety issues and the validity and or otherwise of landlord certificate or leaseholder deeds of certificate, which we'll talk about a little later. Where you are acting on behalf of a buyer of leasehold property, I would always warn a client that the information that's produced by a landlord in an LPE1 may be correct, but if it's defective, the only right of redress is an action for misrepresentation against the landlord, which is fraught with danger. A, misrepresentation is often quite difficult to establish. B, it can be quite an expensive form of litigation, even in the county court. And C, there's no guarantee of success. So you've seen that case involving Japanese knotweed in the London County Court just recently, where the claim was worth £32,000, but the legal costs involved, which had to be paid by the unsuccessful seller in that action, was nearly £170,000. So there aren't many clients I know that would be prepared to risk £170,000 in connection with a claim against a landlord. So I think client buyers need to be aware of that fact. As far as the landlord is concerned, then the landlord needs to answer the LPE1 questions honestly as possible, but for leaseholders, there needs to be a health warning with regard to information that is produced. What happens if a landlord gets a reply wrong? Well, as I say, an action for misrepresentation can potentially be made, but would our leaseholder client have an appetite to do so? So I think you need to warn the seller client or the buyer client about that risk or that vulnerability. Again, do be aware that if the landlord or relevant managing agent is ARMA accredited, then it might be that they will attempt a disclaimer or limitation within the LPE1 for defective responses. The ARMA produced guidance for their membership in connection with the old LPE1s. That guidance is subject to review at the moment. I haven't seen it yet. There is government guidance that deals with landlord certificates and leaseholder deeds of certificate. There isn't any government guidance for landlords with regard to the production of LPE1s or the production of a landlord certificate. In other words, liability in the event of a defective certificate. I've got some views about that I'm going to share with you in a moment or two. The LPE1 requires the landlord to produce a leaseholder deed of certificate and a landlord certificate. If a landlord certificate is defective in connection with a relevant building, and a relevant building for our purposes at this point in time is any building with 2 or more residential units within it, then the position is that if a landlord gets things wrong in a certificate or fails to produce a certificate, that any remediation costs that the landlord incurs relevant to the Building Safety Act 2022 or fire safety regulations, of which there are a number, the landlord cannot transmit that cost into service charge. In other words, the landlord has to take the hit. The problem with that, of course, if a landlord is taking a hit with regard to irrecoverable costs, there may be an insolvency issue that could ultimately be problematical for a leaseholder.